afternoon, Your Honors.
We'll be live in 5, 4, 3, 2, 1.
This Honorable Court of Tennessee is now in session.
Before we call the case, let me mention to you that we don't anticipate any technology-related problems, but if we should have any, everybody just take a deep breath and relax, and our experts will work us through it. Call the case, please, Madam Clerk.
James P. Little, MD, et al. Versus City of Chattanooga, Tennessee.
We'll hear from the appellant.
Good afternoon, Your Honors. To begin, there are two interests represented in this case, one of municipal governments and one of the people that they control. And there are two statutes at issue, TCA 651-102, which involves preconditions of annexation, namely B5, which forbids a municipality from annexing additional territory if it hasn't completed plans of services for previously annexed territories. The second is 651-108, which outlines the rights of residents of annexed territory after the annexation. Part C, the predecessor of Part C was adopted in 1974, which relates to the annual reporting. Part E, which allows aggrieved property owners to sue to compel defaulting municipalities to complete the plans, was adopted in 1998 at the same time as 102B5. The General Assembly gave municipalities the right to annex in 1955 to allow for the orderly growth of cities. But the key to the door was always the promise of services and infrastructure to facilitate that orderly growth. The enabling statutes define the relationship between the two parties in the context of annexation by ordinance. But as the years went by, the legislature found it necessary to adopt additional statutes to compel municipalities to hold up their end of the bargain. The General Assembly finally issued a moratorium on annexation by ordinance, but it realized that no matter how many remedial laws it passed, it really couldn't trust municipalities with the power to annex by ordinance. But the legislature chose to keep these statutes in place so that previously annexed Tennessee citizens could continue to avail themselves of the statutes. This court and the Tennessee Supreme Court have already ruled on some of the issues at play here related to the responsibilities of annexing municipal governments. But this is also a case of first impression as to some of the issues and requires the court to interpret some of the enabling statutes for the first time or in new context. This conflict began for the appellants when the city initiated a major annexation campaign in 2009 and proposed to provide services to 16 additional territories without providing them to previously annexed territories. Plaintiff Little specifically requested the services and was denied, requested de-annexation and was denied, followed the mayor's directives to create density on paper to justify the provision of services. Then when it became clear the city was going to require the plaintiff to provide the services, he withdrew his application, renewed his request for de-annexation in a petition with his neighbors, and was denied again. The city didn't try to work with the plaintiffs. The city, after admitting it didn't provide the services openly, forced the plaintiffs into this litigation. If that weren't enough, the city initiated eminent domain proceedings in another court during these proceedings, all the while telling this court that they fully complied with the plan of services. The eminent domain proceedings were to provide sanitary sewer that the Chancery Court found would be substandard. It was a grinder system that's not used anywhere else in the city that would only provide sewer to maybe 25 dwellings.
Does that have any bearing on the issues before this court?
It does, because the city's initiation of the eminent domain proceedings is itself an admission of default. So, initiating those proceedings. I
don't see how an initiation of an eminent domain action is an admission of fault.
It's an admission that they did not provide sewer to the area. So sewer still wasn't available in the area.
Is there any ruling that this panel can make to address that issue?
Just that the city materially and substantially failed to comply with the plan of services. There's still properties in both areas that don't have access to sanitary sewers. Does that answer your question?
Well, I understand the latter. I just don't understand the former, why the eminent domain is at issue in this discussion.
It was intended by the city to be punitive in a sense because it
Is there anything we can do to give you relief?
aside from compelling the city to actually provide the quality of sewers that were originally anticipated and intended.
And that doesn't require us ruling on the propriety of the eminent domain.
No, Your Honor, it does not.
Okay, what I'm trying to do is encourage you to move on.
Yes, Your Honor. The conflict really began back in 1974. This is a unique case in that the city actually had a long window of opportunity to change its mind about annexing these territories. They had a chance to think very carefully about exactly what parts of the county they were annexing, what it would take to provide them services, and actually put on volumes and volumes of proof to the Tennessee court system about exactly what services they would provide. The standard the city chose to present to the Tennessee Supreme Court was the standard in the fringe studies that they had commissioned prior to the annexation. The city argues that this is all about the level of services. It's not all about the level of services. City records are replete with decisions not to provide certain services to certain areas altogether. But if there is a question of the level of services, it would be very easy to look at the Hicks case and the volumes of proof that the city put on about exactly how deplorable the conditions were in the areas and exactly what services the areas needed to relieve the areas of the, quote, material retardation of those areas. Now the city, in the Chancery Court, the city was arguing that they did comply with the plan of services. Now they're sort of arguing they really didn't have to provide all the services to the whole area, but had discretion about when and to whom to provide the services. So once they annex, the city gets to decide what they do because the plan of services itself is very basic and doesn't actually spell out the level of services. Now it seems that the city is saying, based on when certain laws were adopted, that it doesn't have to provide services to anybody who was annexed between 1955 and the 1974 Act, even though they've been in the city limits and been paying taxes for all of those years, because they argue that a brand new scheme for annexation was somehow enacted in 74. It's the same scheme that was enacted in 55. We just have additional remedies for aggrieved annexed citizens and for those who would be annexed and for cities that might be competing.
Isn't at issue the annexation from 1972? And I don't know how 1954 has anything to do with what we're supposed to decide.
The city argues in its brief that the 1974 Act created a new system for annexation. The 1955 Act is what created the system that allowed municipalities to annex in the first place. So it's the same system. The 1974 Act just changed the burden of proof and provided specific services that had to be included in a plan and other things. The 98 Act is when 102B5 came in, barring cities from annexing additional territory, and also when 108, what is now 108E came in, allowing aggrieved property owners to sue municipalities to actually compel them to provide the services, which wasn't available before. I think it's pretty clear from previous case law that that those, and from the language of the statutes, that they were intended to be remedial. The fact that the legislature kept them means they're meant to be there so that the people who've been annexed, who still don't have the services, have some tools at their disposal to compel municipalities to hold up their end of the bargain. The city warns this court that applying the statutes as written would have a detrimental effect on municipalities. But the appellants would argue that that was what the statutes were intended to do. They were intended to make the cities complete the plans of services if they hadn't completed them. For compliant municipalities, there are no implications at all. Again, one of the the time for regret, if the city regrets annexing the territory, or there are more people there to provide services now to 50 years later, that would be, it's too little too late. The time to make that decision was before annexation or within the timeline, because the statutes do allow for amendment. The city hasn't amended the plan of services. They have gone outside the enabling statutes to the contraction statute to de-annex territory that they didn't want to provide services to after collecting 30 years of taxes from the people, which is another issue in and of itself that should be answered. Can the city go outside the statutory scheme to do that? And I see that my time is running out, so I will stop.
You have your time for rebuttal.
Thank
We'll
you.
hear from the appellee, please.
May it please the court, I'm Phil Noblet. I'm with the City of Chattanooga Attorney's Office at this point in time, and this matter relates to two 1972 plans of services that were adopted as resolutions 9166 and 9168 at that time. And there's no dispute at this point in time that services were provided to both areas 4 and 12 in those resolution requirements. The only dispute has been as to the level and the timing of when services were provided for all areas. This case involves continuous discovery, requests for Rule 9 interlocutory appeal back in 2016, motion practice over sanctions, and attorney fee rewards over continuous litigation for 3 years after this case was initially continued in 2014 until it went through at least a 10-day trial in 2016.
Counsel, let me stop you
Yes.
from discovery and motions.
Yes, sir.
You've got some threshold issues where you say that the plaintiffs can't even bring this action. Don't you think we should consider that first?
I'll be glad to argue those. And that's what I referred to in our brief as the gateway errors in this case. And I was going to try to make those as 4 points initially and then go into them for you. The 4 points, at least I would argue in this case, is that the case should not have been tried initially based upon the law that was in effect at the time of annexation. The city has argued that the Chancery Court incorrectly applied the law when it held the city to an unreasonable standard 40 years after the annexation, and the city had in fact complied
what you
with that
call an
70.
unreasonable standard, what
Yes,
you're
sir.
really meaning to say is you don't think the court was correct in saying the more recent statute can be retroactively applied to
Yes,
this
sir.
annexation.
Yes, sir. And as this court has ruled previously that there's a presumptive effect that it is only applied later in the Allen case, I wanted to make sure, at least in that regard, I discussed that a little bit with you here. The retroactive effect to a 1972 annexation is inappropriate because the 1974 ordinance was not in effect. The case law in Hudson is very clear from the Supreme Court that you can't apply something to a governmental entity whenever it was not in effect at the time. Clearly in Hudson, it said that nothing contained in this act shall affect annexation proceedings initiated prior to the effective date of the act. This one clearly was. And that is an error from the beginning that was asserted by the parties on the city on summary judgment at the beginning of the case.
So what you're saying is that the tax-paying citizens have absolutely no right to demand the city to do what the city should have done.
No, sir. They have the right to go to their legislative body, demand those services, and request those services from them. And that body is, as a legislative body, makes the decisions on those matters. In this case, the property owners are asserting disputes over a sewer issue. They have never paid sewer fees. There's been no issue of where they have actually applied or requested sewer fees before. The only discussion about, I guess, any type of eminent domain is trying to provide sewer access, and then they would pay sewer fees. They have a sewer processing station right next to their property, but it can't be hooked up. That is one of the requirements that says that you have to have easements, you have to work with the governmental entity in order to have access to properties. And these properties were developed on septic systems. There has not been a failure of the septic systems that we've been established in the courts. But that's one of the issues. More on these points, at least as direct. Yes, sir.
Counsel, before you leave that, but
Yes, sir.
so under your view, then, is there any recourse to the parties in court, or do they just have to go and ask the legislative body to do something?
Well, the legislative body is pretty well resolved it at this point in time, Your Honor, after 3 different changes to the annexation statute over the term.
I'm sorry, I didn't mean the General Assembly. I meant, you said the property owners have to go to the city council or whoever it is and the local legislative body, make their demand there.
Yes, sir, and it is a budgeting issue.
And if their demand is ignored, do they have any recourse in court?
The argument, at least at that point in time in court, is if there is improper action by the body, then there could be some potential for a mandamus action compelling at that point. That is the situation I believe that we're looking at in part in a case here that the statute was changed in 1998 to reflect that. That was not in the law in 1972 at the time the annexation began, was initiated, and the law has to somewhat control as to what the governing body was doing at that point in time.
All right, under the law that you say controls, what could the property owners do?
The property owners could address their council members, make a request for services, and in fact, those services were offered to be provided in this record.
I'm just asking what generally like the architect make a request to their council members.
Yes, sir.
Say they're turned down.
Okay, they were not in this case.
Council, I understand. My question to you is, let's say they were turned down.
Yes, sir.
Do they? What's their next step?
Their step could be to file an action in court for mandamus to compel what should be done. Yes, sir.
All right.
As I understand the law. Yes, sir.
Thank you.
Okay, but retroactive application of a 1974 and 98 legislation to a 1972 annexation is inappropriate. Likewise, there has to be some ending of this affair at some point in time on statutes of limitations, estoppel grounds, or standing grounds in connection with this. The Littles were not an aggrieved property owner in Area 4 or 12 at the time of the 1972 annexation ordinances were initiated. They sought a mandamus order in this case after a while, but 27 years after that annexation had occurred. The plaintiffs bought into this area, purchased multiple parcels, knowing the services that they received, but they began acquiring more parcels in the same area after this happened. There is no requirement under 651-102B5 or 651-108 or 108E that would be applied to this annexation because they did not exist at the time of the 1972 annexation in this matter. We would assert that they are asserting a private cause of action in this case that is not allowed under the statute. They were not an aggrieved property owner, and you can't bring an action when you were not there at the time the annexation occurred. If there had been some charging of cost for sewer services in connection with this case, that might be a basis for a mandamus claim here in connection with this matter, but that did not happen. The Littles have never paid 1 cent in sewer costs. They have been on the property since 1999 and have not paid any costs. The effective dates of the law, I believe, is very important to review. I've spent a good bit of time on that in the briefing schedule here because Chapter 753 of 1974 is not applicable, at least according to Hudson, in this matter. And I don't think this court can overturn the Tennessee Supreme Court in making a ruling as to the Hudson decision. The 1974 Act completely changed the methodology and the requirements for plans of services from that point forward. They were not applicable at the time in 1972, and the requirement for publishing reports and progress on a newly defined plan of service was not adopted until the 1974 Act. It also did not add the mechanism for mandamus until after the 1974 Act. And it clearly states within it that nothing contained in this act shall affect annexation proceedings initiated prior to the effective date of it. That was the ruling for Hudson and Hicks, which has been asserted by the plaintiffs in this matter. Hicks clearly involved 4 annexation areas, not just Area 12 or Area 4 as asserted in this matter. And there were multiple areas that were on appeal in that case to the court at the same time. I am not aware of any reported case that's ever applied the 1974 Act to a pre-1974 annexation, and we would submit that the court's ruling denying summary judgment in this case was inappropriate based on Hudson. And I believe that's the only way that this court's decisions in Allen and City of Knoxville versus Knox County and Kane versus Churchill can be read, because they were applying 1998 law at that point in time based upon the statute. And I'm not aware of any 1998 legislation being applied to a pre-74 annexation. So those are the concerns that we have in this matter. Little was not an aggrieved property owner in the annexed area at the time of the annexation. These plaintiffs are not aggrieved property owners with the right to assert the remedy under the statute. We would also assert in this case, because there are claims that have been asserted in this matter that have been ruled on by the trial court below, that we don't think that there is a proper remedy. Because the remedy is not available regarding stopping other annexations based upon the rulings of Judge Marie Williams in the other cases where this argument about 651-102B5 should challenge any annexations that were done after the Little properties were brought in. During the pendency of this litigation, there has been no, determination by the court that 651-105 or 102B5 could be asserted to stop other annexations. The plaintiffs purchased this property in as late, and the other properties as late as 2020. And as such, I believe they're barred by any statute of limitations. The longest statute of limitations that is available under the law is 10 years. In this case, they have filed their initial complaint almost 29 years after the alleged breach in providing services. And if it's considered to be August the 31st of 1982 and 1999, that was more than 12 years that they bought it. So if there's any endlessness to litigation in matters like this, someone has to make a determination as to what statute is appropriate. There's nothing referenced in the statutes here, but the general rule under Tennessee law is the longest you get is 10 years.
If we agree with you on the gateway issue, does that render all other issues moot, predetermined?
I believe that at that point in time, there is that should have been the end of the case. Yes, sir. Unfortunately, we have dealt with the aspect in this matter of discovery for a long period of time. There are issues as to the boundaries and the discovery disputes that we asserted under Rule 37 in our cross appeal that we believe were appropriate as well. But this case at least should have been resolved at that point in time as beyond the time for someone to be able to assert based on those gateway issues. The judge in this case went in and was trying to, at least I believe, split the baby as we're going further and trying to use his equitable powers, which I applaud him for, but his equitable powers are not based upon the aspect of anything that was in the initial plan of services for Area 12. Area 4 was found to be appropriate in his rulings. Area 12, he found that there were some problems. He agreed to have road improvements and also for sewer improvements in those areas. Based upon those splitting of the baby's costs in this matter, those are substantial capital improvements to areas that were not referenced in any of the plan of services. There is an argument here that somehow the Hensley-Smith report is incorporated within those documents, but even the Hensley-Smith reports did not provide for 100% of coverage in all areas of every square foot of land to have sewers or roads on them. There were extensive witnesses in this case, and I think there was 23 or 25 witnesses that testified in the first phase. We've also had phase 2 and 3 in this case, which have now resulted in 192 exhibits in this case. And all of those documents clearly establish that the city has provided services over the year. The question is whether the level of services is appropriate. The Cane Hill case, this court held that the court may not reinterpret the terms of a plan of services. That's one issue, I think, in connection with this case that this court needs to review, because the trial court was trying to at least make sure that there were some provisions added to both sides to get this matter resolved. But there's been plenty of proof in the record that at least the 85% of the structures within Area 12 with buildings on them have sewer. And if they're within 100 feet of a city sewer or gravity sewer, then they're entitled to have coverage. And then 99% of those in Area 4. I had an extensive arguments here about unforeseen circumstances or future changes that also were presented to the court in phases 2 and 3. I won't go into that right now because those are in our brief, but we assert that there's been considerable changes over the years based upon the federal regulations and the state regulations, which required us to be able to vary how those services are being provided, but they are done. We have also made an extensive bit of argument as to Rule 37 and the requirements as to what is a requirement for issuance of cost and attorney's fees. This matter was resulted from an initial complaint being filed with a map on it that was incorrect, and the parties followed that for 2 years before we learned it, and we brought it out to the court, and then we were penalized. That's all I have right now.
Counsel, we'll hear from the appellate rebuttal.
Yes, first I'd like to address the 1974 law. The only thing that came in that would have an issue in this case was the reporting. The 1974 Act clearly said it would not affect annexation proceedings. At that point, annexation proceedings for these two areas were complete. Hudson actually says this case, the Hicks case, wasn't affected by annexation proceedings. The city didn't have to go back and do and adopt a new plan of services. They didn't get stuck with the stricter burden of proof, none of that. But nothing about the Act says it doesn't apply. The Act actually was adopted before the annexations became effective because of the Hicks case. So at the point the 1974 Act is adopted, these annexations were not effective. So it applied, it just didn't apply to annexation proceedings per the language of the Act. Another thing about the statute of limitations, that 10-year statute of limitations doesn't apply when the statutes themselves prescribe a statute of limitations. 108E says anytime 180 days after until it's done, because it was enacted to make cities complete the plan of services, whether they were adopted in 1955, 1998, or 5 years ago. Similarly, 102B5 doesn't prescribe a specific plaintiff that can bring an action. If the city was acting outside its powers and failed to meet one of the preconditions of annexations, then any annexations enacted knowingly while the city was in default should technically be voided. Another of the issues was this 100%.
But again, that wouldn't apply to this case because the annexations occurred in 72.
It would not. It would not. It would apply. The city openly in city council meetings in 2003 and then in 2009, actually in conversation with the plaintiffs, readily admitted that services had not been provided in this area. The 2003 annexations, it was District 1. It was areas.
Providing services is one thing. Affecting the annexation process is another, isn't it?
Yes, Your Honor. 102B5 is in the section that's a precondition. So just like cities have to adopt a plan of services, commission a study, if they haven't completed a previously adopted plan of services, they're not in a position to annex. So then they would be overstepping their annexation rights at that point. It's a precondition. That action has been brought in the Somerville case by a competing city. It has been brought by people who were going to be annexed. It has not yet, until now, been brought by somebody, by a group of people who have already been annexed. But certainly the diversion of substantial municipal resources away from providing resources to them to provide them to 16 additional territories is an issue and a violation of their right to the services, especially as
Now,
they.
in this case, your client bought the property years after it was annexed, and knowing that the services had not been rendered, at least not to the sufficiency and completeness that you believe is appropriate. But
Correct.
you're entitled to enforce the 72. You're entitled to use the new legislation to enforce the 72 Act or resolutions, even though you didn't own the property then.
Correct. By virtue of being an aggrieved property owner in the annexed territory, per the language of 108E, that's all it takes. You just have to be an aggrieved owner of property. The plaintiff in this position actually had to act as a sort of private attorney general in a sense, because he's suing to compel the municipality to finish the plan for the whole area. But he's not the only one who would be benefiting from this.
And have you cited authority that says it's kind of like coming to a nuisance? Can you buy property after the fact and then complain about the services? Have you cited authority that says that?
The only case that's actually addressed 108E is the Churchill case. And that case didn't make it far enough to answer that question, or perhaps the people who didn't have the services, it doesn't say when they brought their property. I don't think it was an issue because the language of the statute is clear. You just have to be an aggrieved property owner in the annexed area who doesn't have the services. It doesn't say you have to have purchased the property. Everybody who had purchased is dead. I mean, at this point, sorry.
All right. Thank you, counsel. Your time's expired. Court's thanks to both lawyers for their briefs and their oral arguments. We appreciate your presenting this to us. Madam Clerk, if you will, please adjourn court till tomorrow morning.
This Honorable Court of Tennessee stands adjourned.
Thank you.
Thank you.